Everyone, welcome to our next episode of our SIPAC webinar series. We're very excited to have you join us tonight, and we're very excited to have two distinguished practitioners who are partners in our Asia member firms. First of all, we have Carla from the Cruz Marcelo firm in the Philippines, and then we have Giang from the Vietnam office. We'll start with Carla. Carla, if you would go ahead and share your screen and share your PowerPoint, then we'll turn the time over to you and have you introduce yourself a little bit more and also your firm. There you go. Perfect. Okay, you need to unmute. You're muted right now, Carla, so unmute yourself and start over.
Good. Okay. Can you
There
hear
you
me?
are.
Can you hear
There,
me?
it's perfect.
Okay.
Perfect.
Good evening, everyone. I'm Carla, Pingul from Cruz, Marcelo, and Tenefrancia. We're a law firm based in Manila. Our law firm does general practice and litigation, intellectual property, corporate law, and under litigation, I do arbitration. Personally, I handle domestic, international, and foreign arbitration in different institution and ad hoc arbitration. So for today, I'd like to share my little knowledge on techniques to save time and cost in arbitration. So most of the time, they'd say arbitration is less costly than general litigation. But I'd say as a practitioner of both litigation and arbitration, that's not true. Arbitration is actually expensive. But even if it's expensive, there are ways to actually cut the cost, time and cost, because if you're a lawyer in Manila or elsewhere, the timely charges of lawyers handling arbitration could be costly, or the cost of the institution could be costly. So in each stages, so for tonight, we will go through each stages of arbitration where we could actually save time and cost. This is actually something personal to me because I'd like, as I always say to our clients in Manila and our international clients, as a lawyer, I always wanted to be cost effective. Not only effective, but also cost efficient. That is important to me because I don't like clients who maybe are winning, but at the end of the day would just say this is just a paper victory because this arbitration cost me a lot. That is not something that I enjoy doing. So this is really a personal advocacy of mine that there are ways to cut costs in arbitration. So for the first part, cutting costs in arbitration actually starts in drafting the arbitration agreement. Most of the time, the arbitration agreement is just part of the whole complex of commercial contracts. That is just one provision that would oftentimes not reviewed much when parties already agreed in commercial terms. But if you really want to cut cost, actually one best way to cut cost in arbitration process is reviewing the arbitration agreement itself. So I have you um tips. Number one, keeping the clause simple. Simple, clear drafted arbitration costs will avoid uncertainty and dispute over the meaning and effect. They will minimize the risk of time costs being spent on disputes regarding, for example, jurisdiction of the tribunal, the process of appointing arbitration. So this is a general recommendation by all practitioners. Keep the clause simple because if you make it intricate, there is a possibility to make it pathological clause. A pathological clause. What is a pathological clause? A clause that nobody could understand and could not give effect to. So keep it simple. Number two, to save on costs also, we recommend using model clauses of institutions. The use of standard arbitration clause is recommended. An example is the International Chambers of Commerce model clause. You can see in your screen, very simple, yet very effective. We want to use model clauses because the institution itself has already tested this. model clause. You don't want anything that will make this complicated. But of course, you can modify. Modification to the standard clause can be an unintended and have an undesirable consequences. Actually, for model clauses, they also follow already the complex phases of commercial disputes. There are it used to be before there's just one model clause for everyone. But now different institution would actually provide different classes of model clauses depending on your need. And it's for free. So we recommend using model clauses. Number three, selection and appointment of arbitrators. This is very important. Rise to small disputes where three-member tribunal may be too expensive. So when you're drafting your clauses, there is already an option. Do I appoint a sole arbitrator or a tribunal of three-member tribunal? So adding special whether one or three, it depends on the complexity of the case and what the parties agreed on. Please note that adding special requirements regarding the expertise and qualification of arbitrator to be appointed will reduce the pool of arbitrators and may increase the time taken to select an arbitrator. Let's say you place in your arbitration that you needed a European with an engineering background who has worked in the construction industry for 10 years. If you will specialize on that, there might be cost on that in terms of time. Selecting those small pool of possible arbitrators. So keep it simple, as I mentioned. Next is consider fast track procedure. Consideration may be given to setting out fast track procedures in arbitration clauses. Fast track procedures are designed to enable arbitration to proceed quickly given the nature of the contract and dispute that are likely to arise. What are fast track procedures? Maybe like if it's 20 million pesos, or in terms of dollars, if it's $20,000 and below, a single arbitrator through a no hearing arbitration could be implemented. So this is actually in the last 5 years, fast track arbitration procedures, they offer a wide variety of options for big and small claims. But I actually highly recommend fast track procedure, most especially also for small claims, because you don't want that the more time you prolong an arbitration, the more expensive it is. So the best for small claims, if it's just a sole arbitrator, the faster you could rule on it, that's more time efficient and cost efficient. Next, time limit for rendering an award. One common use provision can be used to signify difficulties is to require that the final award be produced in a certain number of weeks and months in commencement of arbitration. It's not necessary that this be included in the clause because, as I said, keep it simple. But all throughout the proceedings of the arbitration, you might or your lawyer might need to actually tell the tribunal that if it could be consented, if we could render the award within the certain point in time. For institutions, actually, there is already a built-in requirement on when they should, or the deadline for issuance of an award. But of course, that could be extended in a way. More detailed arbitration agreement after the dispute has arisen. If the parties agree to submit a dispute to arbitration after the dispute has arisen, they can consider specifying more details of procedures for the arbitration. So, if there is already an arbitration clause and then there is a dispute already, this is what I like about arbitration. Parties can actually still talk on how they could hasten or how can they make arbitration cost effective. Not because we are in dispute that we won't talk anymore. In arbitration, if there is a more efficient way on how we can resolve this, parties need to explore that option. So, how do we select the right counsel? Counsel with experience. Consider appointment of counsel with skills necessary for handling arbitration at hand and who are sensitive to the needs of the appropriate time and cost efficiency. Of course, you have to review the experience, the educational background, and the technical know-how also of the counsel. If most especially if that counsel will have time. But at the back of my mind, if I were an in-house counsel, I would really have to see if the counsel is time and cost efficient. For in-house counsels, it's very difficult to just give work to an external without experience on handling cost. So I'd go for someone who's competent, but at the same time very cost efficient. Counsel with time, I mentioned. Ensure that your counsel have selected at sufficient time to devote the case. Your case deserves to be prioritized. In terms of arbitration, my experience is that a single practitioner might have difficulty delivering it on time. So actually, I'd select a counsel with a good team, not only a team head, but I will also consider the experience of the other teammates. Next would be selection of arbitrators. Of course, we need to select the best arbitrator for our case. The use of sole arbitrator. After the dispute has arisen, consider agreeing upon a sole arbitrator when appropriate. So when is a sole arbitrator appropriate? It's usually appropriate when the case is not that complex and that you want a swift and cheaper alternative. Generally, I say generally. So in the Philippines, for the institutions here, if it's $20,000 below, they would recommend using sole arbitrator. Again, different institution would have the same rules. I think in the ICC they have a rule that if it's less than X number of amount, it should be sole arbitrator already. In the Philippines, our institution will actually want you to agree first. If you don't agree, then the tribunal will, three-member tribunal will be appointed. Selection of arbitrators. Select an arbitrator with time. Because usually, arbitrators, especially those famous arbitrators, would have many arbitration at the same time. They're handling arbitration, different arbitration at the same time. So you want an arbitrator with sufficient time to actually study your case and could rule on the matter at hand in the best way possible. Let's just say 6 months. Because if an arbitrator is too busy, we don't want to prolong arbitration for a year or a two-year arbitration. Next is the selection and appointment by the institution. Consider allowing the institution to select and appoint the tribunal, whether sole or three-person tribunal. If you are not aware of the pool of arbitrators available, usually the the each institution would have a selection process, or at least they will issue their trained and accredited arbitrators. So you could use that. Usually that's also for free. If you're not asking them to appoint, at least you could have the list of their arbitrators. Um, Next would be avoiding objections. Any objection to the appointment of an arbitrator will delay the constitution of the tribunal. So if there is no, of course, when there is an arbitrator, you have to review his background. If there is no something that is objectionable, please avoid making objection, because challenging an arbitrator would actually cost you time. And then appointing another one will cost you money. Next. Selecting an arbitrator with strong case management skill, most especially the tribunal head. A tribunal that is proactive and skilled in case management will be able to play its role in the managing of arbitration so as to take it as cost and time effective as possible. So if your lawyers, like in the Philippines, the arbitration community is small. If your lawyer is from the Philippines, or if you're in the same jurisdiction, um you have to know, you would actually know who are the arbitrators who will have full schedule, or who are those with good management skill. And it's a great consideration if the arbitrator could finish a case, let's say in 6 months, because he's very good with strong case management skill. Most likely we will select that arbitrator. Next, when you already selected your counsel and the arbitrator, now it's time to file your request for arbitration and the answer if you're the other party. So a request for arbitration, keep the request simple. It's not just the main case. So there are two views on this. Should the request contain only a minimum, or should it provide elaborate case management statement of the case? Personally, in my experience, I'd like to request to keep the request for arbitration simple and not yet make it evidentiary. I'll just put the basic clause, a background of the dispute, and this would be my arbitrator, and this is a request. Of course, depending on the institution, you have to check the rules. Setting out of a detailed statement of case. If you opt for the other option, putting your case in the request for arbitration, there's also a positive point in that. Institutional rules do not require pro positive option a positive point for stating all claims in the first pleading is that it's already complete. You don't need to repeat it in every next submission. So if you're that kind of lawyer or you're an in-house counsel who prefer to just put it out there, this is an option. Personally, this is not my strategy. I'd rather go with simple and see how the other party reacts first or the explanation to the answer so I could properly strategize for my case. But if it's an all out, you have to detail it because you want the arbitrator to immediately understand your case, I would understand. Okay. Next would be the selection of language of arbitration. Determine the language by the tribunal. If the parties have not agreed on the language of the arbitration, the tribunal is likely to determine it for you. Of course, select a language that is understandable by both parties. If you would select a foreign language that is not understandable by both parties, most likely you will get an interpreter. But that again is cost. So if the parties could just agree that the language would be something that is understandable, let's say English as a universal language for both of you, that would be good. Next, if the proceeding will involve two or more languages, I have experienced this. It's actually very expensive because of the translation services and the transcription of the case. One is translated in English and one is translated in French. That's actually, I think, a third of the cost of the arbitration actually went to the transcription and the interpretation. So let's just lower the cost by choosing a language that both parties are familiar. Now, if you want to cut costs also, we have to establish the framework of the arbitral proceedings. How? When you already filed your request and there is an answer to the request, there would be, and the tribunal is constituted, there would be a case management conference. So, timing. Usually, the tribunal to convene a case management when drawing up a terms of reference as soon as possible. Consider whether it is most efficient in holding a case management conference immediately after the signing of terms of reference. For me, I'd like to have the case management because I'd like everything to be consented by the parties. And then this is my first time to meet my tribunal. From a strategic point of view, I'd like to see my tribunal in person or at least via Zoom so I would know the demeanor and I would, because at the end of the day, litigation and arbitration, we cannot remove the human factor in it. So I would like to see the person who I am reposing my trust to. So I am pro case management. I think if I have limited money budget, I'll give it to this. One of the things I'd ask for is the case management. So preparation. For case management conference to be effective, the tribunal should consider asking the parties well in advance of conference to submit a joint and separate case management proposal. Usually, an effective tribunal will give you a copy of the draft terms of reference from which you could already comment. And if you could already reach out to the other counsel, if there are ways that we could provisions that could be admitted or evidence that is in common, we could already agree to that. Or if we could limit the issues already in the drafting of the terms of reference, that would be, again, a cost-effective move. Providing information in advance of the conference. The more information the tribunal has about the issues in the case prior to the conference, the better it will be placed to assist the parties in devising the procedure that will deal with the dispute as efficient as possible. So, for example, a tribunal that has made itself familiar with the details of the case at the outset can be proactive and appropriate in making tailor-made suggestions to the issues. For example, the claimant listed 10 issues. Respondent listed 20 issues, when in fact the issues are just 5. So a well-informed tribunal who has studied everything could actually trim the issues to 5 issues. So give information as much as you can. Now, the scope. Whenever possible, the procedure for the entire arbitration should be determined in the first case management conference and reflected in the timetable to be established. Be proactive in drafting the timetable. Months, days, the more expensive it is. But you don't want to rush the arbitration. You just want the proper timing. So if you want to limit the scope in terms of time, please do so. Next, do you need your client in case management? Usually the tribunal would allow it. Personally, since it's not much cost for the client, I'd like him to attend to actually meet the arbitrators. And if there is a possibility of negotiation, I would always say this in my class, a negotiated award or a compromise is always a win commercially. We don't want to be in dispute as much as we can. A compromise in a negotiation is a win. So maybe the client attendance with the client attendance of the other party could actually be a process, would open options for the parties to actually agree and not go to dispute. Next would be for case management. Do you need a physical meeting? Consider whether you can hold it via videocon, telephone, or other similar means. Before the pandemic or this video conference thing, I actually had the case management through telephone, a telephone conference. It's an hour of telephone conference, and I find it amusing because my team is in the Philippines, the other team is in Singapore, and the tribunal is in Europe. But nonetheless, we're able to do a case management in an hour. So if it's a physical meeting, would have gone to France, but that would be expensive for all the parties. So if it's a case management and it would be too expensive to see physically, I would go for a video conference case management. Next, the use of apportionment of cost. Usually, to the extent of which party has conducted the arbitration in an expeditious and cost-effective manner may be taken into account by tribunal in determining who shall bear the cost. How could we, since this is the tribunal will actually provide for a decision in cost. Usually it's jurisdiction, if there's jurisdiction issue, the subject matter itself, the issues, and then lastly, the cost. I'd like to know as early as case management on how the tribunal will rule or how would they want to go about on ruling on the cost. So make an inquiry about it. Further case management. Do you need another case management? Consider holding further case management conference during the course of arbitration as appropriate. If only appropriate, because you don't want to do another case management and move the time. In my experience, we just had a second case management when there was an additional party, and as part of due process we had another case conference. But if there's no due process issue, or if it's an additional issue that could be agreed by the parties, and actually not go for another case management conference because it will again have cost and time implications. Terms of reference: the summaries of claims and relief sought. The arbitrary tribunals will consider it appropriate to draft summary claims and relief sought. So review the terms of reference as a draft, make a comment, and actively participate in the case management where the terms of reference is being considered. President of the tribunal to rule on procedures. I would actually agree on this because if the three-member tribunal will always have a meeting that will have a cost implication, and if it's just a simple administrative matter, we could empower the tribunal. Administrative secretary, do you need one? Consider whether you need one or the tribunal could just go on without it. This is also an expense. Counterparts. You don't need to sign the terms of reference in person together. You could sign it elsewhere with the counterpart provision in the terms of reference. The need for physical meetings, again, if it's just signing, maybe there is no need. The need for a hearing. It's not always, there are arbitrations that would not need for a hearing if it's agreed. But personally, if I am allocating my budget, I'd actually want a hearing, especially for the most complicated cases. Fixing hearing dates. If the hearing date is necessary, then early the proceeding, consider fixing the dates because there's already a timetable. So let's follow the agreed hearing date. Usually, and then 1 day for the tribunal to ask the witnesses. Pre-hearing conference. Could be before the tribunal secretary. If it's a video conference, we could just check the equipment, if everyone is heard, if this is the document I'll be sharing. Please use pre-hearing conference to make it more efficient. Short and realistic time period. So, when deciding upon the length of the final hearing and the amount of time required for all procedural steps, choose the shortest time that is realistic. Don't while we want this to be finished in the short-term period, we don't want to rush arbitration. We want to have a case that is presented well. Bifurcation or partial awards. If you have a jurisdictional question, you might want to ask the court or the tribunal to rule first on jurisdiction before you actually could go to the substance of the case. This is a decision by the tribunal. So they could issue a partial award. If you're not a party to this arbitration, you would want to ask for a bifurcation that there is no jurisdiction over you. Procedural timetable, briefing everyone involved in the case. I think this is briefing your witnesses that we have a timetable, briefing your external lawyers, your internal lawyers, everyone who's involved in arbitration, briefing that this is, that we have a definite timetable and we should all follow it. Settlement. The tribunal should consider informing the parties that they are free to settle. They are free to settle at any time before the award, even in the award. And there could be an award based on a compromise. Settlement initiative taken with the parties' agreement. So the parties could actually agree if there is. It could actually inform the tribunal that there are settlement agreements and there are settlement initiatives, but the arbitration could go on. Subsequent procedure for arbitration. Written submissions. Do you want to make your written submissions come in different forms? Do you want to make it long, short? Do you want it to make it repetitive? So those are the choices that the client and the lawyer should meet. Setting out cases fully in trial, I mentioned earlier, do you want your case request to be full-blown submission or just short one? If it's full blown, actually you cut the cost of repeating it, but strategically it might not be the best option for you, but it's you and your lawyer's choice. Avoiding repetitions. Avoid unnecessary repetitions of argument. Once party has set out its position in full, it should not be necessary to repeat the arguments at the latter stage. Sequential simultaneous delivery. Could ask for the claimant submits first, respondent submits after. Usually that's if it's a responsive pleading, but if for witness statements, it could be submitted simultaneously. Would cut time again. Specifying the form and content. Ask already the tribunal, what do you want the form is? What would be the easier? Would it be question and answer or an affidavit form? That way there's uniformity and that it would be more readable to the tribunal. Limiting the length of the submission. If there's just 50 pages, that would be better for the tribunal. Being direct to the point will actually save you cost and time. Limit the number of submissions. Do you need a reply? Do you need a reply after a reply? So you want also to limit the submissions by the parties. Organization of documents. From the onset of the case, parties should consider using coherent system of numbering and identifying documents. Usually for institutions, they already have guidelines for this. So you want to organize your documents both physically and digitally. Producing documents that the parties rely. Parties will normally produce each document upon which they intended to rely. In arbitration, we are required to, if it's there is a document, to actually provide the documents ahead of the hearing. Bundle of documents, that's what we call it in arbitration. So everyone would know the documents that we are relying on. Establish procedures for requests for production. Consider whether a request for production of documents are genuinely necessary. If you have all the documents, you don't need to bother the other party for a request for production, because this will again entail more time, because you will be requesting, they'll be responding or objecting to, and the tribunal will rule on it. So this is more of time. And of course, the hourly cost of the lawyers. Documentary evidence, managing request. Um, Time and cost is associated with request of production. I already mentioned this. Copies of the same document appended to their statement. So if the parties could already agree that this is our common exhibits, that would be time efficient. Selection of documents to be provided to the tribunal. It is wasteful to provide arbitrators with documents that are not material to determine the case. So make sure that the documents you're presenting would actually support your argument and not would just unnecessarily prolong the procedure. Keep hard copies to a minimum. Consider minimizing the volume of papers that's needed to be produced. So, exchanging documents in electronic form can reduce cost. Translation. Try to agree how translations of any documents are dealt with. Reducing the need for certified translation will help lower the cost. Authenticity of documents. Consider providing documents produced by parties are deemed to be authentic unless and until authenticity is challenged, because presenting a witness just to authenticate a document, well, again, it has a time and cost implication. Correspondence between the counsel. Avoid unnecessary correspondence between the counsel. The tribunal may consider informing the parties that persistent use of correspondence may be viewed as unreasonable conduct. If they keep on filing motions every now and then, the tribunal should step in and tell them that unnecessary motions will not be entertained. Sending correspondence to the tribunal. Avoid sending correspondence between counsel and the tribunal unless a decision of the tribunal is required. Limiting the number of witnesses. Every witness adds to the cost. When the witness statement is prepared and considered, and when the witness attempts to give oral evidence. Usually, personally, I like the rule of three. If I could only limit my witness, even in more complex cases, to three, that would be good for me. I don't like presenting repetitive statements from different people. Strategically, it's also not good. Minimizing the number of rounds of witness statements. Usually, I just need two. Um, the general affidavit and counter affidavit. If we require more rounds of witness statement, that would again have cost implications. Expert evidence. Do we need it? The presumption that expert evidence is not required. It is helpful to start the presumption that expert evidence will not be required, because if we keep on thinking that I need an expert when in fact it's not needed, expert witness could jump up the price, the cost of arbitration. So determine first, do you need one? And if you need one, is there a genuine need to appoint an expert? Should it be appointed by the party, tribunal, or both? Or it could be no expert at all. Clarity regarding the subject matter and scope of the report for expert evidence. It is essential that there be clarity in early stage over the subject matter and the scope of expert evidence to be produced. This will help ensure that the parties appointed by the parties have similar expertise and could address the same issues. Number of experts, do you need 10 when in fact you just need one? So just can keep it on a limited number. Usually you just need one, even for more complex cases. Meeting of expert. Expert will often have been able to narrow down the issues in dispute if they could meet and discuss their views after they have exchanges report. So is there a need for experts to meet? But in arbitration, there's already concept of hot tubbing, that the tribunal will call every expert witness and they could ask questions and they could comment on each their of their reports. The use of single expert. Consider whether using a single expert. I already mentioned it, because maybe for both of us, the tribunal could just appoint one expert and then it could be used by both of us. Minimize the length and number of hearings. So we're already in the hearings. Hearings are expensive and time-consuming. If the length and number of hearings requiring physical attendance of the tribunal and the parties are minimized, it will reduce the time and cost of the case. Choosing the best location for the hearings. Hearings do not need to be held at the place of arbitration. Seat of arbitration could be different from the physical venue of the hearing. Let's say in Manila, even if the seat of the arbitration is in China or Singapore, if we are all Filipino lawyers and all Filipino clients, maybe the physical hearing is cheaper to be here in Manila, so we could consider that. Telephone or video conferencing. For procedural hearings, consider the use of telephones or video conferencing. Even in the main hearing, we could consider this. Provide submissions in good time. The tribunal should provide all necessary submissions sufficiently in advance of any hearing for the tribunal to read it ahead of the hearing. Cutoff date of evidence. In advance of any document evidentiary hearing, consider setting a cutoff date after which no new evidence will be given to the tribunal. Identifying core documents that it needs to read in preparation for the hearing. So you're helping the tribunal understand your case. Agenda and timetable. Consider agreeing on agenda and timetable for hearings. Usually, it would be nice to, if there's a cross-examination, maybe an hour of cross-examination. I'd want to limit the cross-examination because in my experience, there is a cross-examination that took about 5 hours and it lengthened the arbitration process. But if I were the arbitrator in that case, I would have just said 1 hour for cross-examination. Avoiding repetitions. Consideration to be given whether necessary to repeat hearing written statements or oral arguments. Do you need another witness for this? The need for witness to appear. Prior to any hearing, consider whether all witnesses need to give oral evidence. But usually, I'd like my witnesses to personally appear before the tribunal so they could see the conduct of my witness. The use of written statement as direct evidence. Time and cost can be saved by limiting or avoiding direct examination of the witnesses. So there's no need for totally oral testimony. Just use affidavits. That would be cost efficient. Witness conferencing. Witness conferencing is a technique which two or more experts are presented in more. So if I have a budget, I would tend to agree with put money in this if I can allocate. I will allocate because I'd like especially for expert witness, that the tribunal could answer the comment, ask, and for the comments of the witnesses. Limit the cross-examination. I already mentioned it. Closing submissions. Do you need a memorandum? A memorandum could tie up everything. But it could also be expensive. If hypothetically we could budget our money, I'd give closing submissions something. I'd like to submit a memorandum so I could tie up everything and explain my theory with all my witness statements and my rebuttal statements in my closing memorandum. Costs. Using costs to encourage efficient conduct of service. Allocation of costs can be useful tool to encourage efficient behavior or discourage unreasonable behavior. Let's say if there is a motion for extension, a party could be penalized for, let's say, $10,000. If there's a penalty for extending, I'm sure the parties will comply with the timetable. Anticipating the time required. This is already deliberation and award of the tribunal. Before closing proceedings, the tribunal should ensure that the time has been reserved for each arbitrator's diaries for deliberation and prompt anticipation. Prompt completion of the award, the tribunal may use its best effort to submit the draft award as quickly as possible. And special consideration, if there are multi-parties, adopt a procedure for multi-parties and multi-contract cases. If you're writing one, consider this. Consolidation. If there are many cases, you might want just to consolidate in one tribunal. That would be cost efficient. The use of emergency arbitrators. Issues to consider before initiating emergency arbitration. For institutional rules, the emergency arbitrator allowed the party to seek interim measures. So I find this quite efficient because it's fast. And lastly, issue consider before initiating. Second, whether there is an application for emergency measure under the rules is preferable by interim measures or in the state. So usually for interim measures, do you get it with court, domestic, if it's a domestic, or do you get it internationally? So that would be something else to think about. If you want to think about the cost, I think it's the effectivity on how you could have the interim measure. That's all. Thank you.
Oh, Carla, that was outstanding. Thanks so much for that excellent presentation. I have a couple of observations and then a couple of questions. My observations, first of all, you have to recognize that I am not a disputes lawyer. I've been a corporate commercial M&A lawyer, and I've drafted a lot of these clauses. And you're right. Often we're not paying much attention to those clauses. I think that this was the most practical presentation that I've ever heard on arbitration. And I think that all of our Chinese lawyers, whether in-house or law firm lawyers, found this to be extremely beneficial. In that regard, I just recently had a conversation with a partner in one of the top Chinese law firms who mentioned that he had had the opportunity in the last year or two to work side by side with a big international law firm on an international arbitration case. And he said that he learned a lot from working side by side with a very experienced international line, or who views this later will feel the same way about your presentation. It's also an important time in the development of the Chinese legal services market. I've been in China for more than 30 years, and for the last 20 years, I've been projecting that the big area for cross-border legal services was going to be in connection with disputes. But actually, it's been slower to develop than I had expected because in the earlier days, we saw a lot of cases where the Chinese parties, rather than have to go through the challenges of working through an international arbitration or legal proceeding outside of China, they would often just simply settle, often on very disadvantageous terms. But I think we're now at a position where we see Chinese clients, Chinese parties are being much more sophisticated about all of this. And I think this is a really important topic. And I was thinking, and actually I've raised this question for people online to comment by WeChat or otherwise to our team. I think it could be very interesting for us to, in the future, have some of our international arbitration experts from our SIPAC firms come and do essentially a full day or most of a day training session that people could come to and really learn the ins and outs. So those are a couple of my observations on the overall approach. The second thing of the observation side is that I was very glad that you talked about language of the proceedings, because this is something that for lawyers such as myself who've been drafting these clauses over the years, it was always a major point of discussion whether we were going to have arbitration in dual language or just one language. Obviously, if it's China related, in other words, in the old days, everything was inbound into China. So it was usually China nexus. And so there was going to be Chinese law that was going to apply to some level, and there was going to be Chinese practice. And so it was always a preference, of course, for the Chinese side to want Chinese language proceedings, but the foreign side felt that they would be at a significant disadvantage. The Chinese side would feel that they were at a disadvantage if it was in English. But now, again, I think we see increased sophistication of Chinese parties recognizing that international disputes probably should be conducted in English because that's going to be the most likely common language. So I was really glad you mentioned that because we've seen this. We've actually had conversations with people about this, and dual language arbitration is very expensive, very time consuming, and does not necessarily improve the result in our experience. Okay, so now those are my observations. Now my questions, I have two.
Mm.
One is that I've seen in some contracts, and you mentioned as one of your examples a construction contract. And I always say that a major construction project is simply a laying the foundation for future disputes because almost every construction project has disputes. But I've seen in a lot of those construction contracts that they may select, they may have an option for certain types of issues to be resolved by referral to an expert, a technical expert. Do you see that very much? And do you think that's helpful to do that as a separate track before you even get into arbitration?
Well, that is actually one of the trends right now in construction arbitration to have a board, a dispute board for
Mm,
construction before arbitration. Actually, I would tend to agree with that trend because construction it's a big commercial investment. You want it to, even if there is a dispute, you want to nip it in the bud, or even if there's a dispute, you want the construction to be ongoing even if there's
right.
already a dispute.
That's right.
So I would tend to agree that that's one of the good points of having a dispute board just to resolve issues while the construction is ongoing rather than wait that there is already a delay or there is a non-completion, then go to arbitration. That could be costly.
Now, there's a parallel question, and that is we hear a lot now about mediation as an alternative to arbitration and court litigation, but I'm not sure that I see a lot of mediations actually being used. What's your experience? Do you think it's becoming more common, more attractive, and do you think it's useful?
But I don't think it's used by many already
Right.
because while mediation could be effective, there is no resolution. I mean, there is a difficulty finding resolution, even most especially if the parties are really not talking or really aggressive against each other. It would be good if the parties are actually consenting or participating in the mediation. But right now, and as much as I want, personally, I want to settle things before even going to arbitration. And as much as I think they're still in an infant stage.
Right.
But I think many people are already making an effort to make it an option. And I would agree with that, but right now I don't think it's the most effective one.
All right. Now, my last question, and this is something where we've had a discussion with some of our partners in our member firms around the world at different stages, and that is the alignment of the arbitration the venue and the applicable law. So, for example, and then there's also a broader question, and that is anticipating where the disputes are likely to arise and who is likely to be the party bringing the arbitration and the party responding to the arbitration. In other words, who is more likely to be in breach and anticipating also when you're going to, where you're likely to be enforcing the arbitration award. So, for example, we had conversations with our friends at ENS Africa in South Africa about this, and they said that if a Chinese company is supplying products to South Africa, it's probably better to select South African law as the governing law, have the arbitration there in South Africa, because if you do it where it's Chinese law, but then it's arbitrated somewhere else, you have to find an arbitrator that understands Chinese law, or you have to have a Chinese law expert. That adds to your cost. But then there's the cost of enforcement, because then you have an extra step in some places. Those are all the things. So I probably made a few comments there, but if you could just in 1 minute or less sort of
Yes.
summarize how you think
Okay.
those things fit together.
It's two. It's substantive law versus procedural law, which is the seat of arbitration. I actually would, if you just want cause and there is no question as to bias, it would be nice to have the substantial law of the contract and the procedural law, which is the seat, in the same jurisdiction.
Right.
Because it could be more, it would be easier for you to have this confirmed, the award. But I do under and then it would be, you're right, it would be so expensive to bring to bring a Chinese law expert in Africa just to prove the substantive law. So I would tend to agree with the observation that if you're really cutting costs and there is no bias issue in the jurisdiction, that there
Right.
are not um there are no not pro their countrymen, I would tend to agree that it would be good to have the same jurisdiction as to the substance and the procedure. But if you're anticipating, that's a good thinking. If you're anticipating for the procedural rule or the law of the arbitration or the
Right.
seat, you would want to choose a seat that is pro arbitration. Apart from cutting costs, I think that would be the number one consideration. It's not the cost, but you'd like to think if the seat of arbitration is pro arbitration.
Hmm. All right. Well, I just already demonstrated that I'm not an arbitration expert because I didn't use some of the right terminology, and I appreciate you're using the correct terminology. But sometimes you have to be patient with transactional lawyers such as myself, but we need to consult with experts such as yourself as we draft contracts as well. So thank you very much, Carla.
Thank you so much. Good evening, everyone.
All right, now we'd like to welcome back Giang from YKVN, which is top firm in Vietnam. We're so excited to have them as a member of SIPAC. And now, Giang, if I see you're sharing your PowerPoint, if you can just expand that so it's full size, and then go ahead and please uh, introduce yourself, your firm, and and then start with your presentation.
Yeah. So you don't see the full screen?
No, that's fine. Go ahead, please. You
Okay.
can make your whole page this is fine.
I am Giang, a partner with YKVN Hanoi. I joined YKVN 3 years ago. Before that, I worked with Alan Slinklaters.
Recording in progress.
We also got a lot of awards over the past years, as you can see on the screen. So today I would like to talk about 3 key topics in the power industry. So the first topic is power development plan and investor selection. The second topic is competitive electricity market and DPPA. And the third topic is self-generated and self-consumed power. So I saw on the screen a list of the key legal instruments for power now. So first of all, it is the law on electricity issued last year and took effect from early this year. And we have the revised power development plan number 8 and its implementation plan. We had Decree 56 implementing the law on electricity. This decree covers planning and also LNG to power. Decree 57 on DPPA and Decree 58 on renewable. So now I go to the first topic. The new law on electricity highlight new policies and today I just want to focus on renewables. You may know that Vietnam has committed to net zero by 2050 at COP26. So now we are in the transitional period. And we also have LNG to power projects in the pipeline, but I don't really see interest from Chinese investors in LNG to power. So today I just focused on renewable energy. For power development plan, there are 4 key plans. We have the national power development plan, which is the biggest one, which covers the largest projects, and then it has an implementation plan. And at the provincial level, the provincial plan includes the plan for development of power supply network, and it has also an implementation plan. You can see on the screen which projects should go to the national power plan and which projects should go to the provincial power plan. For example, a project of 50 megawatt or more should go to the national power plan, and project of less than 50 megawatts should go to the provincial plan. So there are criteria setting out which project should go to what power plant. So in this slide, you can see the specific capacity allocated to each type of power source by 2030 and 2050. And you can see that by 2050, so wind or solar power wind account for a big portion out of the total capacity. So in this slide, I just want to summarize that for renewable, by 2030, the capacity will reach 28 to 36%, and by 2050, renewable will go up to 74 or 75%. So in this slide, I would like to look at the investor selection process. So most of renewable energy projects will now subject to bidding for selection of investors. As you can see that before a project can be implemented, it must be included in the one of the 4 plans as I mentioned. After a project is included in a plan, then at the proposal of the relevant competent authority or the investor, the investment policy approval will be issued. And after the plans are issued, the Provincial People's Committee also issue a list of the lands for the projects that have been included in the plans. So basically for all projects, the Provincial People's Committee will hold the bidding for selection of investors. But note that for offshore wind, the Ministry of Industry and Trade will be the authority responsible for organizing bidding. So all the steps for bidding will be as indicated on the screen. So first of all, the bid invitation will be issued, and the PPA draft included in the bid invitation will have to contain the price. And then after the investor is selected, the winning bid price will become the ceiling for negotiation of the PPA price. Here you can see that I've highlighted here that the winning bid price will be the ceiling for negotiation of the PPA price. So it means when you want to invest in a renewable project in Vietnam, you have to go to a bidding process, and unless you are selected in that process, you cannot get the project. So now I talk about DPPA. This is quite new in Vietnam. Only recently we have new regulation on DPPA. So first of all, for competitive electricity market, Vietnam regulation of Vietnam set out the competitive market in 3 stages. So first of all, we have the competitive generation market. We already completed this competitive generation market, and then we develop the competitive wholesale electricity market, and we are in the middle of this. And after we complete the wholesale electricity market, we will develop the competitive retail electricity market. And having to participate in the competitive market is a bankability issue for power project. Why do I say that? I say that because once you participate in the market, the payment that you can get will depends on the calculation by the national operator of the market. So it may go out of control. And for all renewable projects having the capacity of more than 30 megawatt, will have to participate in the competitive wholesale market. But for renewable projects from 10 megawatt to 30 megawatt, it is optional to participate. For those projects not having to participate directly in the market, I mean for those indirectly participating in the competitive market, then the PPA price can be negotiated between the seller of electricity and EVN. And the PPA price will consist of three components, being the fixed cost, which is the cost for recovering investment costs, the FOMC, which is a component to recover O&M cost, and VC, which is a variable cost. And this can be used to recover fuel input cost or other variable cost. But variable costs only apply to like LNG to power or waste to energy. For renewable project, VC is considered to be zero. In the competitive market, the price, the payments to be paid to the seller of electricity will include three components. So first of all, it is the spot price, which is the price calculated by the national operator based on the offers of the seller of electricity on the market. And the second component is the payment under the contract for difference. So the parties will agree on the quantity to be on the output to be purchased under the PPA, and this component will be calculated by multiplying such agreed output with the difference between the PPA price and the market price. The market price means the spot price I just mentioned. And the third component is the other cost, like a connection cost or other tax or fees. Why do I talk about competitive wholesale market first? Because for the PPA project, if it is not a physical DPPA project, then the project have to participate in the wholesale electricity market. So for the PPA project, there are two models, being the physical models, in which the seller of the electricity and the buyer of the electricity will connect with each other via private wires. And the financial or virtual DPPA, in which electricity is sold directly to the national grid. For the DPPA mechanism, the customers participating in this mechanism must be last customer who has the monthly electricity consumption of 200,000 kilowatt hour or more. So this is an illustration for the physical DPPA. As you can see that it is very simple. So there is only a PPA between the seller and the buyer, and the buyer is not it comes from the private sector. This is the financial DPPA or virtual DPPA. And this is more complicated than physical DPPA. You can see that there is one PPA between the seller of electricity and EVN, or an EVN power company, and EVN is the state utility company. Under this PPA, the seller of electricity just sell electricity to EVN via the spot market, and the price under this PPA will be calculated by the national operator, as I mentioned. So the second PPA is the one between the last customer and EVN. So purchase electricity from EVN. Why do I say the payment here will be the cost in the market and the cost for retail electricity? I explain more in the next slide. And the third contract is the forward contract, or it can also be called the contract for difference. That is a contract between the seller of electricity and the last customer, in which the party agrees to pay to each other the difference of the price agreed in the contract and the spot price. So, for example, if the price in this CFD is higher than the price in PPA 1, then the generator will have to pay the last customer, and if the price is lower than the price in PPA 1, the last customer will have to pay the difference to the seller of electricity. So in this slide, I am set out in more detail how the seller of electricity is paid. But I guess this is a bit technical, so you can have a look at the slide, and if you want, you can obtain my slide via SIPAC, and you can also contact me directly after this webinar if you want to discuss in more detail. So the payment to the seller of electricity will consist of the payment in the spot market and the payment under the CFD, as I explained. And in this slide, it is the payment that the last customer have to pay. It will be the payment under the contract for difference. And there are two scenarios under the contract for difference, as I explained. So it may have to pay the seller of electricity, or may vice versa, the seller of electricity may have to pay it. And for the cost in the market, the last customer has to pay EVN. And for the retail cost, this only apply in case the electricity that the last customer need to use is more than the electricity that the seller can generate. I start to receive a lot of inquiry on DPPA, but DPPA is still very new in Vietnam. Actually, I have seen some DPPA in the market already, but this is still very new. So this is the opportunity. If you want to invest in Vietnam, then I see that people start to negotiate DPPA with each other. So I would like to move to the next topic on self-generated and self-consumed power. So this is a new concept in the regulation on power. Previously, when we don't have the concept of self-generated and self-consumed power, I see that in the market, people still enter into corporate PPA with each other. Companies from the private sector, i.e. not the state utility company, still sign PPA with the power seller. But recently we have the concept of self-generated and self-consumed. That means under this model, organization and individual can produce power for its own use. So the existing corporate PPAs in the market do not fit within this new concept. And under this concept, so the EVN and the price for such surplus electricity will basically be the average market electricity price of the preceding years, and the self-generated and self-consumed power can be rooftop solar or wind or other type of power sources. However, so far I see that the most popular form is rooftop solar. It is notable that for rooftop solar, the surplus electricity that can be sold cannot exceed 20% of the total electricity output that the seller can produce. And for other power sources, the surplus power that can be sold to EVN cannot exceed 10% of the actual electricity output. So as I mentioned, in the market now, there are PPA that were entered into before we have the new concept of self-generated and self-consumed powers. And now, since we have this new concept, people start to enter into equipment lease agreements. So previously, the project belongs to the investor who has the solar panels. But now the project owner is the customer who wish to use the electricity produced from the project. So the customer will have to be the project owner, and they lease solar panel from the investor, and it will lease those panel and also engage the investor to install these panels and do the O&M services. However, the equipment lease model is not yet officially recognized under regulations. So there are risks involved with this model. And actually, in the market, I can see that this has become more popular, and a lot of people already carry out the equipment lease model. But at YKVN, we don't actively recommend that people should do this until there are official regulations from the authority on this model. However, we have started to do a lot of due diligence for investors who wish to buy in those projects with this equipment lease model. So that is the end of my presentation. Here you can see my CV, and you can access more detail of my CV by clicking on this link. So after this webinar, you can contact SIPAC and obtain my slides, and I'm very happy to discuss further with you if you have any questions or any inquiries about power industry in Vietnam. Thank you very much.
Thank you for that presentation, Giang. A couple of observations. Again, I'm a corporate commercial lawyer, but I have done a few projects, not many, but I've done a few projects. And I am very confident that there are many people online listening tonight or who will watch this later who are very experienced and will understand so much of the detail that you've talked about. But I also am confident that there will be a lot of parties, not just lawyers, but also Chinese companies, and particularly their international and strategic projects teams who are non-lawyers, who will also be very interested in a lot of this commercially focused information that's covered under these regulations. A second observation is that as we think about the overall geopolitical environment and the relationship between China and Vietnam, and then between China and the US and Vietnam and the US, right now, because of all of the trade wars and the tariffs and negotiations, we're all thinking about manufacturing and transshipment and all of Chinese companies in the Vietnam market that are not affected by any of those other aspects. And I have a couple of questions relating to this. And one is, based on my very limited experience in this sector and looking at some different rules and regulations across Asia, this was several years ago now. At that time, even for wind power or solar power generation projects, if it exceeded a certain level of production capacity, that then there were going to be some limitations on the foreign investor stake. That, for example, it had to be minority shareholding, sometimes less than, smaller than 30% or something like that. And also there were, at that time, there were some limitations on who could be the management of the company and other restrictions. So when you talk about this part with investment opportunities, are those some of those other rules on caps on foreign investments still going to apply?
Very interesting question. Thank you. Foreign ownership limit is quite popular for other sector.
Yes.
But luckily for renewable, there is no limit for foreign investor ownership except for offshore wind.
Oh, okay.
Yeah, and offshore wind is still very new in Vietnam, and there has been no offshore wind project in Vietnam so far. But the limitation for foreign ownership is there. And especially for Chinese investors, there may be some difficulties. But for solar power and for onshore wind and for even waste to energy and other kind of renewable like biomass, then there is no limitation at all, and the investor can buy up to 100% of the target company.
Well, that's really very encouraging. Now, there's another aspect that there may be a separate opportunity for all of the Chinese manufacturers, producers of solar panels and wind turbines, et cetera, who may just want to be a supplier. But I'm also recognizing that in a lot of jurisdictions, and it may be the case in Vietnam as well, that the government is actually happier if you're bringing the investment and the equipment supply.
Yep.
What do you understand? Are those separate opportunities for Chinese companies, or usually would you expect those to be bundled?
Actually, it depends. They can come to Vietnam. I mean, the investors in those projects as developers and suppliers of turbines can be separate, but they can also come to Vietnam in bundle. And as I can see, Wind, which is a very famous Chinese supplier of turbines, is already here in Vietnam. They have an office here, and actually they have made lots of inquiries with us. So they already have some projects in Vietnam in which they are the developers or suppliers of turbine. Yeah. So in short, those investors who want to invest in projects in Vietnam as developer or supplier of turbines, they can come together or separately. There's no problem. Yeah. Either way is fine. Yeah.
So going back to the question on investment, so there's not any limitation other than offshore wind. The Chinese companies could come in and own 100% of these power generation projects, but are there some advantages in your view for the Chinese companies to come and do a joint venture with a domestic Philippines party where they might have better relations with the government? There may be other things where they can facilitate. What do you suggest Chinese companies should consider in that regard?
I guess that you should have mentioned Vietnam, not the Philippines.
Oh, I'm sorry. I'm sorry. We just had Philippines. You're right. Vietnam, please. Answer for Vietnam.
Okay, very nice question. Yes, so it is very common in the market that in the early stage project and they obtain all the permits.
Right.
Yeah, and then after they obtain the permits, the investor can buy in. But I can see that in other cases, they sign joint development agreement with the local parties and the foreign investors and the Vietnamese party can jointly develop the project from the beginning. So that is a very good way to develop project because the local party can have a more knowledge of the local market and they have like a more connection to obtain the permits. So that is a very
Yeah.
good way to develop the project. And once the project obtain all the permits, then the foreign investor can acquire up to 100% of the project. Yeah. Yeah, that is very common in the market.
Yeah, and I think that that's as long as it's permitted for the foreign investor to not have any cap on its investment share. I think that those same principles would probably apply in many different markets and in Vietnam as well, as you've just explained. My last question, and that is you referred to bankability of these projects. Now, obviously, that relates to the scale of the project and whether bank financing is advantageous to the investor because it improves their leverage and therefore the potential for return. As we
Mm.
all know, banks lend money at a fixed interest rate.
Mm.
But if you can manage that in a proper way, your potential returns can be much higher and can be enhanced by having bank financing. I would also expect that Chinese banks are often brought in together with the investors. So it's investor, bank financing, and supplier all
Mm.
together in a
Mm.
consortium. I think that can be
Mm.
a very successful model for Chinese investors in this sector in Vietnam.
Absolutely, yeah. I totally agree with you. If they can bring in Chinese bank, that would be really, yeah, I expect that would be a successful model to be implemented in Vietnam. And actually, I saw that in the past for large scale project. Yeah, where I see Chinese investors and Chinese bank, and also ECA like a Sinosure.
Right.
Yeah, they all come together, and that can be very successful. Yeah, actually,
And if
we
we
have
look,
precedents in the market already on that.
right, and I would think that this is just my guess that in Vietnam, that other potential competitor investors may be coming from the US, France, because of historical relations, which have both of those have pros and cons. Also, the relationship between China and Vietnam has many pros, but also some historical issues. But Japan and Korea, et cetera. But I think that maybe the Chinese, if they can bring the investment, the supply of equipment, and the bank financing, that it can be very much provide a competitive advantage.
Yes, yes, yes. Actually, for other jurisdictions, they also have their own like a ECA.
Right.
Yeah, the ECA will support them a lot. But I can see successful example from China in the past for
Right.
very large scale projects. So I'm sure that that is a model that should be implemented in Vietnam for renewable as well.
All right.
Yeah.
Giang, thanks so much for your presentation. Obviously, you are demonstrating your expertise, as you have indicated. Everyone who would like to get a copy of your presentation, please just contact the SIPAC team, and we'd be happy to share that. And of course, Giang has been very, very generous to offer to answer questions if you have them. So thanks again. Would like to once again thank our presenters from the Philippines as well. We did have both jurisdictions represented here. And again, a very outstanding webinar tonight. Thanks to you, Giang. Thanks to all who have joined, and we'll see you next time.
Thank you and bye bye everyone.
Bye bye.